Hey, everybody. I want to welcome you to today's Savvy Estate Planning Seminar or workshop that Ron Lang and myself are putting on. My name is Jeff Kickel. I am one of the hosts of The Sense of Things on YouTube and podcasts. And Ron Lang is my co-host with that. And today, Ron is going to be sharing with us a little bit about estate planning and what we need to be thinking about throughout this process. Ron is the president and chief investment officer of Atlas Wealth Management. And I am the president and chief investment officer of Share Horizon Retirement Advisors and also Freedom Day Wealth Management. So with that, I'm going to kick off with Mr. Ron Lang.
Thank you, Jen. Estate planning is something that nobody wants to think about, nobody wants to deal with, nobody wants to set aside time for, and that's always the greatest mistake. So what you're going to get today, folks, is blunt speak from Jeff and myself. There is no any other way to speak. We don't blow smoke, we don't create sunshine, and we don't discuss a lot of fluff.
And we
So whenever you
promise
talk,
we promise that it'll be less painful than going to the dentist today.
we'll see.
Yes.
We'll see. But it's definitely direct conversation about estate planning, retirement, taxes, and planning. And again, in about 45 minutes, it's like drinking from a fire hose, folks. So we're trying to cover some key topics, and anything that is detailed, you got to talk to a trust attorney. So this is going to be our agenda today. We're going to go through it fast and furious, but we're going to give some really good examples to share with you for thoughts, what you need to really do a deep dive, think about preparation, things like that. So as we alluded to, Jeff and I are not attorneys, and we don't play ones on TV. We are trust and estate knowledgeable. We are not trust and estate experts, meaning that we cannot process trust. We cannot put together trust for you. We cannot file trust for you, but we could certainly provide you guidance on things that you need to think about for the future in preparing it, in addition to prepping your investments and portfolio for the best way that your either trust is set up or eventually how your estate will be managed. Two things, if nothing else, that you're going to be getting two of these PDFs pages today. These are very valuable PDFs. They're really good for just general estate planning, things for you to think about, different areas for you to consider. And if nothing else, it's a really good reminder. Because even though we're going to review a lot of these things in the workshop today, these two PDFs will certainly give you the real substance you need to either discuss with your partner or spouse about putting together an estate, or prepping you for your first meeting with a trust attorney, or if you need to do modifications to your trust and estate. These are the things that'll give you to think about that. One thing that we all need to know and consider is life is unpredictable. If you've been around the block once or twice, like Jeff and myself, life is unpredictable. The big golden rule, as we talk about, 4 key words: get it in writing. Mom said when she passes that I'll get this and you'll get that. Verbal, doesn't matter how thick you think your blood is. At the end of the day, when it comes to money and assets, and with some family members, quote unquote, entitlement, doesn't matter. Get it in writing. And look, did we all plan COVID? Do you plan, you're healthy today and sick tomorrow? Do you plan potential loss of a spouse? Of course not. Life is unpredictable. That's why you need estate planning. And it's chuckling and funny, but one of the reasons why people don't get life insurance or set up a trust or an estate plan earlier, because they think as soon as they sign it, they're going to die the next day. Don't laugh. I've heard this from multiple people over the years. I'm sure Jeff has too. It's one of those things where they don't want to think about death. And if they feel like they get life insurance or sign up on a trust or estate, they're going to die tomorrow. Crazy thinking, but it is true. So what is a will? There are advantages to a will, but you should always have a trust in place if possible. So a will is created during your lifetime. It gives your estate to the beneficiaries. You name an executor or an administrator. But here's the problem with a will. It's still subject to probate. And depending on the state you're living in, using Jeff's example, sometimes it's a more enjoyable time going to the dentist than dealing with probate. And it only takes effect after your death, and it distributes your entire state all at one time. So you may think, if I have a will, I'm okay, right? Not necessarily. It does enable you to decide your executor or personal rep. It will control how to distribute your estate, and it names a guardian or conservative for minors just in case. But it does not avoid probate after death, and it will not protect you from mental or physical incapacity. So what is a trust? It's a legal arrangement under which one person or institution controls property given by another person for benefit of a third party. So you're essentially assigning a person or institution to take over your affairs after you pass. A living trust, it's a legal arrangement in which a person, the grantor, places their assets into a trust during their lifetime while they're alive to be managed and distributed according to their instructions, which can occur either during their lifetime or after death, often avoiding probate. So this is basically can be a distribution of your assets while you're still alive. You're assigning a person or an institution to take care of this for you. And special needs trust. We all know how important this can be if you are a special needs parent or taking care of a special needs child or family member. There are many good trust attorneys out there that specialize in special needs. I will tell you, I do work with somebody in the state of Arizona that is a terrific special needs attorney. If you are looking for a referral, there are other considerations, and many people are not aware of this, but there are many government agencies and money available for special needs situations. So if you're not aware of this, you should be, and you should work. Actually, if you go to a trust attorney, they may know how to steer you in the right direction, but they may just refer you to a special needs trust attorney that has much more experience in these areas. So just a consideration if you're in this type of situation. So as we all know, death is unpredictable. One of my sayings over the decades has been, hey, folks, you could put together a 3, 5, or 10-year plan, 20-year plan, but every now and then life gets in the way. I personally have lost 17 people in 7 years, in a 7-year period of time, including my son and my sister. Those were unexpected. And of those 17 people, half of them were tragedy. The one thing that you do know is you can't time anything, including death. Advanced preparation makes life and death easier on everyone. We don't like to think about these things, but as I always said, it's irresponsible if you don't do these things, if you don't think about it. I've actually had some people say, when I'm dead, I don't care. If you care about your heirs, your kids, your grandkids, people that you care about, you should think about these things because death is a legal event. There is a transfer of assets, there's a distribution of investments on a predefined schedule. So if you have advanced preparation on this, you could basically decide how your assets will be distributed, whether it's all at one time or over a period of time. So what happens if you don't have an estate plan? I've actually had people that have been so irresponsible, they say the following, when I'm dead, I don't care. Folks, that's not a plan. And it's irresponsible to your heirs. If you care and love your heirs, I think you need to put some plan in place, whether you like them or not. And this is the kids versus the grandkids. You need to put aside time and think about what your final wishes will be. And you want to think about this before you want to meet with the attorney. Now, the attorney, a good attorney, will walk you through and drive you through and guide you through the process, but you at least want to come in with a basic plan of what you want to get done. So no one to make healthcare decisions on your behalf. What happens if you become physically or mentally incapacitated? Who takes over your life? Because here's the problem. If you don't figure out who's going to take that place, the state will then make those decisions for you. So what happens if there's no one to make decisions on your behalf? You should put into place a durable power of attorney. This is while you're alive. So if you become mentally or physically incapacitated, this assigns someone to make those health decisions, medical decisions on your behalf. Very important to have a DPOA, a durable power of attorney in place. What happens if you are incapacitated? Who's going to pay the bills? Who would transact business on your behalf? If you don't have a POA, a power of attorney, no one would. And what a POA does, if you become incapacitated, you're assigning someone to pay your bills, to transact business on your part. A durable power of attorney allows someone to make medical and healthcare decisions on your behalf. So you really need to have a POA and a DPOA in place along with your trust and will. And a good trust attorney will help you put all this together at one time. So at your death, will your loved ones know where to turn and what to do on your behalf? Would your family know what to do first? Would they know who to call? Would they know where your important papers are located? Do you have pets that need to be taken care of? We all know that many times we like our pets better than our family. So if you care about your pets and something happens to you, who's going to take care of your pets? And obviously, funeral arrangements or whatever your choices are. And sometimes a good trust attorney, depending on your situation, may tell you, in addition to what you have in writing, you may want to make a video of this information. In case I die, here are where the papers are. This is where the list of contacts are for you to call. That's responsible planning on your part. Surviving spouse may not be able to access funds right away. Depending on how you have your account set up and what your trust and estate says, you need to think about it because assets are frozen immediately after death to prevent nefarious activity. So if not done or done properly, the surviving spouse may not be able to pay the bills or even use the ATM machine to get cash. Very important that you take care of this beforehand. So you may want to consider what's called a TOD, transfer on death. So if you have investment or brokerage accounts that have money in it, remember, typically investment and brokerage accounts are not required to have an assigned primary beneficiary. Retirement accounts are. So with investment and brokerage accounts, if you have transfer on death, as soon as you die, you're assigning one or more people to have access to that money as part of the trusted estate. So another one is JTWRROS, joint transfer with right of survivorship. So if your husband or wife, spouses, if one passes immediately, the next person essentially takes over. So these are the things you need to think about. And if you have been working with investment advisors like Jeff and myself, this is standard stuff that when you set up a joint investment account or a joint brokerage account, this is something you're doing almost right away. So we like to give an example. So if everybody knows the deep baritone voice of Barry White, you need to know about what his situation was. Because if you don't set up a trust or will properly, assets may go to the wrong people. So what happened with Barry? Barry White was living with his longtime girlfriend with whom he had 9 children with, but never got a divorce from his wife, never got anything else in writing. And as far as the reduction or removal of rights to his assets or an agreement of a split of assets. So when he died, the former wife got everything. The girlfriend and the 9 kids received nothing. Now, I'm sure this was tied up in courts for a while. I don't know the end result, but just this in the beginning would have put the girlfriend and the 9 children in jeopardy of being supported in any capacity at all. And sometimes you have former spouses that aren't the most amenable to sharing wealth. So you want to think about that. So taxes could eat away at your estate. We have a couple more examples we're going to give you of this. So while they eat away at your estate, the current estate tax exemption is currently over 12 million for singles, 24 million for couples. Now, this was a political football about when the 2018 tax plan expires at the end of 2025, that if it's not continued and it's not grandfathered in, then it reverts back to what it was in 2000, pre-2018, and then it only gets reduced down to 5 million for singles or 10 million for couples. So if you have a higher net worth, you need to think about this, because what about these taxes? Do you need to change your estate, or excuse me, your trust? Do you need to think about, how your investments may be affected with this taxation? Have you take advantage of gifting? And we'll talk about a little bit more about that in a little bit. And on bullet point 3, some states impose their own estate and inheritance taxes. I had come from a state where somebody passes, the state wants their pound of flesh. They want 1% of that estate, no matter the value. So you need to think about that based on the state that you live in. If you're passing on an IRA, your beneficiaries may have to pay income taxes on the distribution. And we're going to talk a little bit more about that too. So yes, the government and their taxes can eat away at your estate that you want to pass on to your heirs. And beneficiaries may be unprepared for new responsibilities. What does that mean? Will they know when to take RMDs in their inherited IRAs? Will they know how to manage a new pool of assets? Maybe your kids are YOLO, right? You only live once, and they're spending everything that they make. Now all of a sudden they come into money, and they know they should do the right thing for the most part and plan for the long term. Now they come into a pool of money. Will they know what to do? At the minimum, have you introduced your children or grandchildren to your wealth or financial advisor, so they at least are introduced to somebody, if they don't have somebody, that can help them make decisions, plan for the long term, either reduce taxation or plan for their own retirement and get rid of debt. And then when the time comes, they will have a relationship with that advisor and at least know the basics of what they can do, and also have a contact phone number to reach out to. So here's another example that you want to keep your estate plan up to date. So everybody knows Heath Ledger. He won the Academy Award posthumously for Batman: The Dark Knight, and he did set up a trust. He was smart enough to do that, but he never updated it after his daughter was born. His 3 beneficiaries were his parents and 3 sisters. Now, this is a situation that does have a happy ending, because even though the daughter wasn't a beneficiary, the parents and the 3 sisters ended up giving all their all of his assets to the daughter. But not all families act in a civil and responsible way when it comes to inheritance and distributions. So this is another reason that we beat into our clients, not literally, of course, that they should be reviewing and updating their trust, if not annually, at the minimum every 2 years. We're going to go through some more examples of this. So how about Michael Jackson, Mr. MJ? He did set up a trust and left everything to his children and mother when he passed. But here's the problem. He never funded the trust or updated it with most of his estate, meaning he didn't include his assets into the fence line of the estate. So everything was outside of the trust. The estate went through probate in California, which is one of the worst states to go through probate to, and it took years for it to eventually get settled. I'm sure there were some additional lawsuits in there. So actually, the children and the mother had to live off at an allowance, which is hard to believe with the amount of money that the mother did have and the children, but who knows what the standard of living they had. But it took years to settle this because the estate was never updated and put all of the assets within the fence line of the trust. So dealing with death with no will or trust, you have no official direction to guide your family. Your family members may disagree about your wishes. Like I said, get it in writing. Doesn't matter what was told verbally, even if it was in person or on video. If it's not in writing, you could almost consider that it never happened. Estate goes into probate and is divided according to state law. You do not want the state to get involved in your affairs. And some people may or may not care about the last one, but perhaps you have no final message to your family members. So estate planning means thinking of dying, right? So death denial is one of the greatest obstacles in estate planning. Denying that you may never die. I'm going to live forever. better living through chemistry, folks, right? Yes, we are living longer. Hey, let's face it. I always like to bring this up. I'm 56. So just take a quick thought. Do you know what the expected lifespan was of an individual in 1912, 112 years ago? The expected life was 54 years old in 1912. I should be dead, right? What is it today? It's hovering around 80, right? Probably every 10 years, we could add another 6 months to a year to that through chemistry, hopefully better eating and living, so on and so forth. But death denial is a huge obstacle. So, with no estate plan, right? Heirs may be subject to a number of obstacles, such as probate, creditors, lawsuits, judgments, legal fees. You list the whole thing. And all of this could compromise the value of your legacy. This is a given. But why should you also make changes to your trust? Maybe you set up your trust 5, 10, or more years ago. You may have more assets now. So maybe 5 or 10 years ago, on how you wanted to distribute your estate is very different because you, again, you everything increased in value. Your house has appreciated. You may want to distribute your estate differently. Your retirement accounts, you were adding to it. It grew over time with the market. Possibly you wanted to do some Roth conversions to reduce the taxation to your heirs. Even if you're under the federal estate tax exemption amount, an increase in assets could call for a different strategy, tools, and decisions about who gets what. This is where a good trust attorney and good investment advisors like Jeff and I come into play. Maybe there's a situation that you have fewer assets now. Maybe you had sold things, maybe you had given stuff away. So perhaps a gifting program, will set you as you set up seems a bit unaffordable today because the maximum you could do this year is 18,000 a year. That just got bumped up to 19,000 in 2025. So if you were doing a gifting program, which is basically you could give $18,000 away to anyone for any reason without a tax consequence to you, without a tax consequence to them, you could do that. That's essentially giving away your estate before you die. You may want to think about that. And what if your assets were reduced in value? Investments, collectibles, cars, you want to think about that. Maybe that might maybe a reason to change your trust. Maybe your kids are older now. I've been dealing with a situation where somebody set up their trust in 2001 and hasn't made any modifications. They set up that trust while their kids were 5, 6, and 7 years old. Now they're in their 20s. You would think that things are different now. You accumulated more assets, and obviously you don't have to care for children that are minors. So you might have to think about how you're going to update your estate for that. Maybe you have adult children now that now they will understand the distribution. When they were 7 or 8, they probably didn't understand that. Plus you may want to start giving away parts of your estate, or maybe the kids may need money now for either your grandkids, their kids, or maybe to pay off debt. And this allows you to give that money to them before you pass. So this way you get the satisfaction of seeing that money be put into good use because you may not be taking the vacations or doing the traveling that you once were when you were maybe in better health and were able to do that. Maybe your kids got married and you have a new daughter or son-in-law. Should you review your kid's marital status and take a fresh look at your estate plan? Maybe you have heirlooms that you want to make sure that stay there. As a quick example, when I had gotten married, I am happily divorced. We're still good friends, but we actually had a diamond, not an expensive diamond. That was my grandmother's. It's a 100-year-old diamond. It has this thing called a miner's cut. Don't ask me what that is, but it was a special, unique cut. Again, it wasn't a big diamond, and we wanted to make sure that got passed down, in our family. So at some time when our son, who now passed on, now I have that diamond, I'm going to give that to my nephew. So when he gets married, he could pass that on as a fourth generation. Maybe you have some family heirlooms that you want to stay in the family. Maybe it's a vacation home that was built by your grandfather or your great grandfather, or a painting or some other collectibles. So these are things to think about for protection. Maybe you have new grandchildren The birth of a new child always requires an estate plan update. For gifting, maybe you want to set up a 529 account and you and your spouse to fund that, because you and your spouse can give up to $18,000 each to help fund that 529 account. And also funding for life experiences. So I have a client, I love to tell this quick story, that he's accumulated a nice chunk of money in his lifetime. He's in his early 70s, and he doesn't give money to his kids or grandkids. He wants to create experiences. So one of the things he recently did, he goes, I said, "Oh, have you done any experiences for your grandkids?" He goes, "Oh, yeah." He says, "I took them all to a concert. I got one of those like super boxes and I took everybody there. We had about 20 people. It was these side street guys or back street guys or something like that." I'm like, "Oh, you mean the Backstreet Boys?" He goes, "Oh, yeah, it was the Backstreet Boys." He goes, "We took everybody. We had a great time." So he wants to create great experiences for his kids and his grandkids. And the other thing a lot of people are not aware about, you can set up a Roth account for a minor. Now, this is key and critical because money will double at every 8 to 12 years, depending on the market moves. So if you could set your kids up or the grandkids up real early, you know, and fund that every year with some money, whether you want to max out or not, because right now you could do a max of $7,000 a year. I mean, they're going to be that much further ahead down the road. And with the Roth account, obviously after the age of 59 and a half, they're not going to pay taxes. So even if it's going to run for 50 or for 40 or 50 years, that's great. Any money that you put in there, well, they're gonna just thank you that much more down the road because the cost of everything is going up. They may not be able to fund the retirement, but the money that you put in there early on will work for them down the road. Maybe you've gotten a divorce or remarried. You definitely need a revision to your estate immediately, right? Because if not, and I had this at a recent workshop, somebody said, "Oh, I thought when I got divorced, I thought that took care of my estate plan." You need to talk to your trust attorney immediately if you have gotten divorced and you haven't made a change yet, or if you're looking to get remarried, because we all know love's better the second time around. Except for Jeff and Crystal. They've been married 30 years. They're happily married. So they're good to go the first time around. So, but again, if you've gotten divorced and or thinking about getting remarried, you have to look at that estate plan and make changes. Because if you don't want your ex to get something when you died, you got to change that immediately. All right. So this is one of the biggest estate planning blunders people make, must be reviewed. So some procrastinate right after they get divorced because they're exhausted. They have felt like they've been just dragged over glass tacks, rocks, and broken glass to go through the divorce. I'm like, all right, I'll get to it eventually. No, do it immediately. Get it done. This will be the next obstacle you can put behind you and move forward with your life. So maybe you're thinking about divorcing or remarrying. So if you're thinking about it, you should consider a prenup. Remember, marriage may be all about love. Get it in writing. Marriage is a contract. So you want to update your trust and estate before you get married. Because once you get married and you want to change your trust and estate and you don't want to include your current spouse, the spouse has to sign off on that. Okay? So if you are looking to get remarried, you want to make sure preferably you do get a prenup, but you wanted to update your trust and estate before you get married. Tax laws change. They changed in 2018. They're most changing by the end of 2025 going into 26. So depending on how you set up your trust and how long you've had it, tax laws may have changed a few times. And guess what, folks? They will change again, probably in another 5 to 10 years. So no matter what that is, you have to navigate those murky waters of tax laws in your state, work with a good a good CPA and a good investment advisor because you want to stay ahead of that curve. So tax laws are going to change. We talked about this. Expect changes by the end of 2025 going into 2026. And you want to review not only your investments, but also your trust. So don't set up trust or as a beneficiary of an IRA or a Roth account. Why? I get this quite a bit. You want to set up your investment account for this because it's a distribution. So your investment or brokerage account you set up as a TOD, a transfer on death, or the joint with right of survivorship. Because if you set up your trust as the beneficiary of the IRA, as soon as that goes into the trust, the IRA has to be distributed. As soon as you do that, it's a taxable event versus identifying the beneficiary as how it's going to be distributed among them, because now it becomes an inherited beneficiary to them and it continue to grow tax free. As soon as an IRA is distributed, you can't put the genie back in the bottle. You can't put the toothpaste back in the tube. It's now been distributed. It's a taxable event. Again, do not make your IRA do not make the trust as a beneficiary of your IRA. Maybe
Ron,
you move.
one little
Yeah, go
point
ahead,
I
Jeff.
want to just make here. A couple of situations where I would say it does make sense to do that. One case would be if you have, let's say you have a kiddo that is really massively irresponsible with money. This is an opportunity to at least keep some of that back. And of course, a Roth distribution, the second one, a Roth distribution is not taxable. So it's really not an issue so much if it goes into a trust at that point. But I would say, especially if you've set up what's called a spendthrift trust, knowing that let's say you've got a child that's got a drug problem or something like that. Yes, the trust is going to pay taxes on that, but at least that money will be kept out of the child's hands or the young adult's hands at that point, and a
Good point.
trustee will oversee it.
Good point. The next one is Jeff and I live in two states, Texas and Arizona, that people love to migrate to or retire to. So if you move to another state, many of the laws governing estate planning are state laws. You need to check into that. You need to go to a good trust attorney in the state either you now live in or you intend to retire in, and find out how those state laws may impact the estate planning that you set up where you used to live. So some need to be drafted anew to comply with the new state's requirements, meaning if you had a trust drafted in another state and you live in Arizona now, your trust needs to be revisited. So just to harp on that for a second. Also, your executor is no longer willing or able to serve. I happen to be an executor on several estates. This was for friends or clients or family that were older than me. Now we're getting to a point, if I'm at a certain point where, hey, I may not be able to be an executor for them because they may have set this up 10, 20, or 30 years ago. So you want to think about that, especially with a power of attorney or a durable power of attorney. They may be at a certain age where they may not be able to take on those responsibilities. And the last point here is you need to have that conversation sooner than later, because you need to make sure maybe you had an executor that may have addiction issues later in life. Maybe they're unable to serve responsibly as your executor. So you want to pull that off, you want to pull that person off. You need to have these conversations sooner than later. Perhaps you've changed your mind about where you want your assets to go. This is a given. You got to a point in your life where you may want the distribution of your estate to change, either to family, heirs, friends, or even possibly charities. Remember, we had discussed new family members, either grandchildren or in-laws. Preparedness is the antidote to fear. Isn't that the case? So common estate planning problems, no will or trust or advanced healthcare directives, a DPOA in place, overlooked provisions such as guardianship for minors. Jeff just brought up a good point there about spendthrift. No tax planning. It's just amazing to me how people don't think about it. And also financial strains, cash shortage for survivors. Okay. So what's missing? Intangible assets, such as character assets, your values, health, spirituality, heritage, purpose, life experiences. These all go into it. How about your intellectual assets, your business systems, alliances, ideas, skills, traditions, reputation, and then the big one as we get older, wisdom, right? A lot of these things, can be looked into also. So just very quickly wrapping up a lot of this is the successful legacy plan in summary. thinking about your spouse, thinking about your children, your grandchildren, and future generations, or perhaps the world at large, charitable distributions that you feel very strongly about. And also Roth conversions. If you want to reduce taxation of what your heirs will inherit, you may want to think about Roth conversions now, especially if you're retired and your tax basis is a lot lower and you don't need the money out of that IRA to live on. Doing a Roth conversion is very responsible to reduce their taxation down the road. And of course, required minimum distributions. A lot of people aren't aware of this, but a few years ago, through the Secure Act changes, if you were born before 1949, you have to do an RMD by 70 and a half. If you were born after 1949, now it's been moved back to the age of 73. So that gives you a little bit more time to consider Roth conversions or to consider changes in your portfolio. So you know that when you make those changes on how that may affect your heirs when they do take it over. And also, I have a couple of clients that do this, that instead of doing the RMD to pay taxes on it, they take their RMD and do a charitable distribution every single month. So this way, the government doesn't really get their pound of flesh. They don't need the money. So their RMD goes to a QCD, which is a qualified charitable distribution. And through your investment advisor, you can set these up. So key points for peace of mind: revisit your trust every couple of years. If you don't have one, your next action item following this workshop is to get one. Have your heirs be part of the process so they understand when things happen. Make sure all your assets or your key assets are in the trust, and also have a will. So if you forget something that's not in the trust, then the will takes over. Also get a durable power of attorney in case you become mentally or physically incapacitated. Very important. And also, we're taking down all your names that have attended the workshop today. You will all get this PDF, if not by the end of today, tomorrow. Both of these PDFs you will find very helpful and very valuable. And it doesn't matter whether you have a trust in place now or you need to get a trust in place. These two PDFs will help you. Jeff and I can tee things up on the investment side and help you prepare for your meetings and conversations with the trust attorney down the road. So we really want to appreciate you attending. We hit the nail on the head here, got it done in 45 minutes. I think there's a couple of questions. Jeff, I'll let you kick it off.
Yep.
And while we're going through these questions, if you have any other questions, just put it in and Jeff will get them.
One of the questions that was in here, Ron, and you touched on this a little bit, but it's really what I see is, and this was a major topic as I was starting to go through the estate planning essentials book and that process. I have a whole chapter on social media assets. So
Wow.
it's a new field within the estate planning world that I'm not sure all attorneys are really even thinking about at this point. So much of our world today is wrapped up inside social media. Even people that are older today, I think, especially during the pandemic period of time, I think a lot of my older clients became a lot more tech savvy, and so much of their lives now are wrapped up in, hey, I'm on vacation or I have family and I'm taking pictures with my phone. So I think it's extremely important to include in that estate plan uh, what's going to happen to who's going to handle my social media assets. I might have tons of photos that are on my phone or uploaded into the cloud. It's not just you inherit mom's, as my wife did, inherit mom's 5 buckets of family photos and photos of people that we have no clue who these people are. Now that's on phones. And we need to be thinking about who's going to handle that, who's going to take that information and put it into someplace else. I remember we just lost my mother-in-law this year, and my wife had gotten a bunch of stuff from her father. And there was a strained relationship with him, but I felt as a fellow veteran, he had served in Vietnam. So as a fellow veteran, I just had to tell his story, even though he wasn't a very nice person. And it took me probably 2 to 3 months of going through a lot of stuff that my wife had and military records and everything else to be able to put together his story from when he joined the military, the pictures that we had that were on slides and everything else. So there's a lot more to this than just that simple thing. So I just wanted to stress that. Couple questions that came up or that were in the Q&A, Ron. Is it correct that I can fund more than $18,000 to my 529s for my kids?
I do know this, when you first set up a 529, you can preload the first 5 years in the first year.
Okay.
So that is a provision in there. So if you got a newborn, if you can afford, or if you can work it out between family that want to contribute, if you can preload as much as you can in that first year and let that baby run for 18 years, they're gonna be pretty good, because who the hell knows how much college is going to cost 18 years from now.
Yeah. But I've done this with clients before where I had a client that owned a large electrical company and they had sold a portion of the company off. It was a side electrical company. And when they sold that, we sat down and talked about what do we want to do with this? And they had 4 children. What we did is we basically went in, figured out, kind of worked backwards and said, okay, what's it going to take for the 4-year-old in 14 years? What's it going to take for the 3-year-old in, 15 years? And worked our way backwards, backed our way into the numbers. And then we just set up 529s for each of those with whatever it would take to fully fund their college. And so it ended up being, I think in the end, it was probably about 150 grand out of the
Fantastic.
sale of this business that we just boom. And I said, okay, now your only concern in your life is retirement planning. You don't have to worry about anything else. You don't have to think about college at that point.
Yeah, no, that's good. All right, what do we got next?
Okay. Should I set up my will first or should I add like all the documents that you discussed?
All right. So I know how this is going to sound. Talk to an attorney. I can't give legal advice on that. I will tell you, get them both. Get a trust and a will done for you at the same time. Yeah, a
Yeah.
good trust attorney will just knock it all out for you at one time. I will suggest, can't recommend, I will suggest the trust is more powerful than the will. It costs a little bit more money to do it, but it's worth it. Yeah, don't feel, oh, I'll do the will now and I'll do the trust later. Talk to a trust attorney, knock it all out at one time.
And I would say for those on the call that are folks in my world in Texas, trusts are not as big of a deal here because our probate process is actually pretty simple in Texas and it's not
That's
very
Texas.
expensive. Once again, the beauty of living in Texas. So it's not as big of a deal here, but if you want to keep your estate out of the public record, a trust works really well. My personal belief, if you are younger and you have children, if you do not have a will, you need to get that done this weekend. And that can be done just something simply online. We use at Freedom Day Wealth and Sure Horizon Retirement Advisors, we use trust and will to do something simple like that. I would get that done immediately, but you still need to do all the other stuff. But if you don't have a will and you have children, basically you're leaving it the rule of the state as to who's going to take care of your kids. And we never had kids, but my brother-in-law would be the older brother-in-law would be the logical one that would take care of them. And I would let him raise a pack of wolves. So make sure you've got a will in place.
Yeah.
Last question, Ron, I didn't hear you mention it, but what is a living will?
We did cover that. It
Oh,
was actually, I think, the third or fourth slide. Tell you what, I'll even go back there. Actually, you know what? You're right. I only covered living trust. That's something that I would say you really need to talk to a trust attorney about that. I'd rather not even come up with a definition of it. But again, at the end of the day, probably a living will is probably similar
hmm.
components to a trust. But at the end of the day, just get a trust and a will, get a power of attorney, and get a durable power of attorney in place. When you
Yeah.
do that, you have now protected yourself.
So, I mean, my answer to that question is a living will is another term for a living will is a directive to physicians. And the reason for that is when you have a healthcare power of attorney, that gives someone else the right to act on your behalf. You're giving that person the ability to act on your behalf for medical things, but it doesn't tell them what your wishes are. A living will or a directive to physician says, okay, in this case, if I'm in a persistent vegetative state, and there's no chance of me coming back, here's what I want to have happen. Either keep me going as long as you can to figure out how to fix me, or I don't want to be there.
The
That's really where
TNR.
it is. And it's what I say is the gift to the person that you are giving your medical power of attorney to. It's the gift that tells them, it's the instruction sheet that tells them, this is what my wishes are when I can't answer them.
Yeah. Okay. Those are all good questions, all important. And in the end, folks, like I said, we can't dispense legal advice. We teed it up for you. Hopefully, we reinforce the importance of getting a trust, getting a will, or if you have them both, get them updated. Look at the taxation, look at your investments. All those things are very important. So definitely appreciate you,
And
showing up today.
one more question
Oh, okay.
that came up, and I can guarantee you this is from somebody here in Texas. What are your thoughts on ladybird deeds for transferring land or homestead?
Oh, I'm familiar with that. Yeah, yeah.
Really complicated.
Yes.
And
I wouldn't even comment on that one.
this is one I usually would wade into, but it's one of those that I would say this is where you need to work with a competent
Yeah.
estate planning attorney in the state of Texas,
Yeah.
because we do have some weird rules around transferring land or homesteads here in Texas that is very unique all around. And where the ladybird deed came from is Lady Bird Johnson, when she was, because she far outlived President Johnson. And so they transferred a lot of land. And so this was named after her at that point, and transferring it to family members and other entities and things like that. So this is one that you really need to work with an attorney. You cannot fly this one.
Very complex.
It's very complex, and you can really screw it up if you don't do it right. So I think that's the last one, Ron. Excellent job,
Fantastic.
folks. One quick thing, when you get out, like I said, we'll be emailing you those 2 PDFs that Ron has, and I'll be shooting out copies of Estate Planning Essentials next week once I get it back from the editor and we get it quickly typeset. Hopefully y'all will enjoy that. I get into a lot of detail in some of these areas that we discussed today, much more detail as you're putting together your plan. When you leave this seminar today or the workshop today, there will be a quick survey. If you would please complete that survey, that'll help us to know what you want to see coming up. And look forward to seeing you on more of these. Keep your eye out for emails on these. Ron and I most likely will be doing more of these after the beginning of the year. We've blown it out this year so far, but we'll start up the new year and do some of this. It's just a way for both of us to share with our audiences. So thanks a lot, and we'll see you guys back here the next time you're on.